skeleton arguments. And can I record my thanks to Mr. Brown and Mr. Shipley and their instructing solicitors for having stepped into the breach, because matters would have been considerably worse and my task would have been considerably more dangerous had it not been for their assistance. Right. My Lord, can I start? Can I indicate the course that I prefer to take?
Yes, of course.
Anything that comes from the court, which is this. I start with the new evidence application, which bears on grounds 4 and 5. And of course, the court will hear me debate an essay on that.
Yes, certainly.
On the basis that although grounds 4 and 5 are presented in the original grounds as separate, they are in substance covering the same ground. Yeah. And my submission to the court will be that now that we have the witness statements that were before Judge Prentice and the small further documents, we're not embarked here on an appeal which requires further disclosure. My submission to the court will be on the basis of what the court has now, if the court is prepared to admit it.
Yeah. Well, I can tell you that, as you rightly say, that we will admit it de esse. I think we are not going to rule on the application today, but we will deal with it when you get the substantive judgment.
I fully understand that, my Lord, and it's not an unexpected response. My Lord, having dealt with the new evidence and grounds 4 and 5, I'll then return to ground 3, where there is the possibly interesting issue of law, depending on how the court views it. Of course, ground 3 concerns, it is set out as concerning findings 3, 4 and 5. In truth, the point of law only really touches on findings 3 and 4. Finding 5 is a freestanding ground as to whether or not Judge Johns should have found that there was breach of an order which required something to be done forthwith, when that issue was not in fact apparently ventilated at all before him. That's a short discrete point which I'll deal with at the end. So, my Lord, dealing with the new evidence application, the test to be applied is not that in Ladd and Marshall, which is the test that Mr. Varma's witness statement set himself, and it is nor is it the Ladd and Marshall test as set out in the Respondent's skeleton argument. In my submission, the authority of Vertelli and Squatrite sets a somewhat lower hurdle for my client to pass, based on the obvious fact that his liberty is at risk, and therefore the test is whether or not it's necessary or expedient in the interest of justice to admit this further evidence. And there are shades of the spectrum of rigour with which Ladd and Marshall is applied in child welfare cases. The court has sufficient flexibility within that test, but there is a somewhat greater degree of flexibility even there in cases of contempt.
Yeah.
And in my submission, it will not surprise the court to hear it is necessary and expedient, although I only need either, to allow this additional evidence on this appeal.
Now, my Lord Justice Stuart-Smith will know much better than I, but as I understand it, you have to give some explanation about why this evidence wasn't at trial. And in the case of people with whom your client might well have been in contact, what is the explanation?
Well, my Lord, in relation to the two categories of evidence here, if we deal first of all with the evidence from my client's son and his former wife and his daughter-in-law and the grandmother, my client's evidence is he was not in contact with them at the time, that there was a family rift, certainly a rift between his son and himself, as a result of his son having been dragged into this whole sorry mess as a result of his father's conduct. And that is the explanation, he says, that he did not have what one might have hoped he would have by way of filial cooperation in terms of saying, Dad, here's what I'm saying. His evidence is he simply didn't have those witness statements.
Well, I might have thought that he would say, son, I'm facing prison.
Well, my Lord,
family rift or not,
Well, my lord,
I'm at risk of going to prison.
Well, my lord, that's right. There is some evidence given by the son in the hearing in front of Judge Prentice, in which the son effectively says, in response to questions from Mr. Brown, and if I don't know.
I mean, if your client's evidence was, well, I asked my son and he absolutely refused to help me, that's one thing. But we don't have any evidence, do we, that he asked?
Well, my lord, the evidence is, well, the evidence, your lordship is correct, we don't have that evidence. If he had asked, he wouldn't have been given anything. If I just read,
right.
Well, can I ask the court to turn it, Supplemental Bundle 3,
Yes.
tab 33,
Yes.
page E899.
899.
899. This is cross-examination of Mr. Varma Jr. Before Mr. Insolvency and Companies Court Judge Prentice. And if one looks at between A and B, Mr. Varma is being questioned about a document. It's actually one of the documents in the additional evidence bundle. Okay, Mr. Varma, can you see this letter was requested by your father? You said they were your father's accountants. He is still helping you, is he not? So this is shortly after the committal hearing. No, he is not helping me at all, and I don't want his help. He simply forwarded this email to me without any communication, and I don't communicate. I didn't reply to him. I just took this letter and disclosed it. And then at E924,
Yes.
at letter C, Mr. Brown says, right, now I appreciate this case has put significant pressure on his surrogate relationship with your father. I understand that. And the response, well, you put that lightly, yes, he won't be seeing his grandchildren. And he then goes on to say, well, before this you were close, which answer was yes. And then finally at 960, which perhaps comes most directly to the point my lord just made, at letter F, sorry, E, it's E downwards. Last section of questions, which is very short, Mr. Varma, just in relation to your new witness statement and the committal hearing your father had last week. You knew, did you not, that we were alleging he's breached various court orders and told various lies? I think that's always been the case if you're alleging, but I wasn't updated in his committals and the proceedings, etc. Well, you knew, did you not, that the committal hearing was last week? Actually, I thought it was the month before. I had no idea the details. Well, he applied to adjourn it on the grounds he had COVID-19, which he did not. Okay. And you communicated with him during the committal hearing, did you not? Not at all. Why would I do that? And then there's a reference to, well, how would you know that we were on an aggressive CFA, which is an issue that has been between the parties, but not something I'm addressing the court on today. So, Lord, the evidence from Mr. Varma Jr. was, I had no communication with him, and when he sent me something, I didn't reply, and why would I be interested in communicating with him when he's facing committal proceedings? In fact, the committal proceedings had been listed on a previous date and then adjourned, so he was right about that. But to the extent that there is a degree of healthy scepticism about a lack of communication and whether or not a request for assistance from the son would have produced help, that's the evidence that was given by Mr. Varma Jr. in my submission. It's inherently credible evidence.
So it's an inference you're asking us to draw.
I'm asking you to draw the inference from the fact that that is the evidence that was given under oath by Mr. Varma Jr. when cross-examined by...
But he does not deal directly with what he would have done if he'd been asked for a particular...
No, it's not specifically put to him, what would you have done if you'd been asked to provide a witness statement to assist your father. I have to accept that. But the tenor of the son's response is, in my submission, tolerably clear. And of course, one bears in mind that this is a son who has been subject to freezing order and robust litigation on the basis that the money that he received from his father, believing it to be an inheritance, is in fact something that he has received, effectively knowing that it was the proceeds of fraud. And one can well understand why there might be a family rift in the circumstance. In fact, it didn't seem inherently improbable to Mr. Brown when he was cross-examining, and Mr. Brown has as much knowledge as anybody of this lengthy case, and might be expected to express scepticism if there was scepticism to be expressed.
Right. What about the other witnesses? Mr. Carter, the daughter-in-law, Miss First, the ex-wife.
Well, the position that in that is we say that they all fall into the same piece, because they're all in the son's camp, they're all supporting the son, and they're on the other side of the family rift.
But there's no direct evidence of a request for.
No, there's no evidence of a request made to any of them for assistance.
Right. Yes, right.
And of course, the evidence that they provided, certainly all save the son, it is in witness statements dated the 10th of June. Now, one assumes that even though they were inclined to assist the son, that was the earliest date by which their witness statements were able to be mustered and signed. And that is during the committal hearing itself. I, in my skeleton argument, have inferred that those witness statements would have been served upon the respondents very shortly after that. We have no direct evidence of that, and it's probably a matter which sits more neatly under the disclosure aspect of the case. But while I'm on the point, if I refer to the final letter in the supplemental bundle.
The bundle 3? Or the application bundle?
Sorry, my apologies, the application bundle.
Yeah.
My apologies. And it's the very final page, it's tab 11, page 105 to 106. This is a letter sent from the respondent solicitors to the appellant's former solicitors on the 27th of October. The relevant part of this is on page 106, paragraph 3.1. This is in response to a request from my client's former solicitors asking for details of when information was received. And one sees at 3.1, with a soft copy of this letter, and we don't have that, we attach the following which were included in the Varma trial bundle, bar the covering emails. And 3.1.2, Keystone Law email of 10th June 2020 with various witness statements and documents attached. We infer that that is the email which included the witness statements that we're now asking the court to consider and to admit.
Yeah.
So, even if the court has concerns about whether or not a request made independently to the former wife and mother of son would have provoked an earlier response, it seems inherently unlikely that it would have made any difference, because her evidence, freely given to assist her son, was only provided at that late stage on the 10th of June. In relation to the wife of the son and the grandmother, their evidence is slightly, well, it's less relevant because they're dealing with a single large diamond ring. That was an issue which, as Judge Prentice pointed out, wasn't actually on the pleadings, but it came to occupy perhaps disproportionate amount of time, because what it really went to was the culture of whether or not jewellery is passed down through the generations in the way that it was said the large cache of jewellery had passed down. And so that was the real purpose of their evidence, and Judge Prentice considered that it was that evidence was credible and supported the approach that the family did in fact abide by what he called the Indian tradition of passing jewellery down. So it's less central to the point, it simply gives more support to the general approach. So
and more generally, the credibility of the son, I think.
Well, Milady, yes, it does. And it's credibility of the son, credibility of the mother, because the mother gave evidence that she had seen and heard certain things in 2017, which, if she heard them, would have to have involved a considerable amount of foresight if they were being said falsely. And she also was able to give evidence about the fact that the paternal grandparents were in fact wealthy, and she had seen various items of ostensibly valuable jewellery being worn from time to time by her mother-in-law.
Yeah.
But it is essentially an issue of credibility at the bottom of all of this, because in front of His Honour Judge Johns QC, my client stood alone, and on his evidence alone, he lost. And one understands why. But if he had been standing beside his son and his former wife, and possibly also his daughter-in-law and the maternal grandmother, our submission is he probably wouldn't have lost on the issues of whether or not the jewellery existed at all, and whether or not the jewellery had in fact been sold, as he alleged.
Now, can I just make sure that I've understood his allegation? Correct me if this is wrong. I understand that he alleges that the jewellery was sold in or about June 2018. Is that right?
Lord, yes, that's the allegation.
Because the son's evidence was the jewellery was sold in the previous year, and the payments from the bank account, from your client's bank account, went out in the previous year.
Well, Lord, if that was the son's account, it doesn't sit with the evidence. It doesn't sit with a letter of February 17, which the mother, the ex-wife, said that she had seen, because there's a wedding that takes place in February 17, in which she says she is told the jewellery is being handed over, and she sees the letter at that stage. But Lord, there is very little in this case that is clear-cut in terms of dates and places. And that is why my client on his own, faced with the background of a number of orders which on their faces were not complied with, one understands why His Honour Judge Johns was satisfied to the necessary standard. But that's precisely the sort of case where the assistance of other witnesses may avoid the criminal standard being met. Now, of course, it has to follow that if the other witnesses had been heard by His Honour Judge Johns, it might not have made a difference because it might have counterpointed other discrepancies between their accounts. That is a forensic possibility. But, and it's also a possibility that my client's evidence would have impacted upon the evidence of his son and his ex-wife, so that would not have been believed. These are all forensic possibilities which have to be acknowledged. But if one steps back and asks the question, given that these witnesses have been believed by ICC Judge Prentice, having been strenuously cross-examined by the same counsel, what is the more inherently likely result if these same witnesses have given that same evidence in front of His Honour Judge Johns? And in my submission, the answer is not difficult to find. It is, there must be a real prospect, to put it mildly, that His Honour Judge Johns would not have been satisfied with the criminal standard or even the civil standard. But what my client was saying about the jewellery existing and how he had dealt with it was false and a deliberate falsehood. And that's why we say this evidence is sufficiently important that it should be admitted.
Right.
And the court, having read His Honour Judge Johns QC judgment and the skulls, will see that before setting about addressing each of the findings of contempt, he specifically took time and put a separate heading over the diamonds and jewellery. And then in paragraph 43, sorry, it started at paragraph 39.
Yeah.
I said, this is a matter that goes to the core of the entire case, and so I'm going to deal with it up front. And that's how it features in the overall process. And we say that again indicates that the impact of this fresh evidence goes far beyond finding one, which is where it is directly relevant, because it leads over into all of the findings of credibility, which serve to contribute to my client's findings of contempt on the other findings. Because by and large, those findings are based on his credibility. And, well, I don't need to restate the point. It's impossible to compartmentalise credibility.
Yeah.
If you lose it on that core issue, you don't get it back. If you don't lose it in the first place, then you have a better chance of avoiding the findings of contempt. So that's why we say this evidence, if it had been there, would not have just affected finding one, but could have affected all of the other findings as well. I accept, it's a point made in both of the skeleton arguments for the respondents, that findings that the jewellery existed and that it was dealt with initially, as my client said, would not necessarily mean that a finding of contempt on ground one, or sorry, finding of contempt number one, need not have been made. But it was the first and certainly a really significant step on the road to making that finding. If His Honour Judge Johns' judgment had started off, this jewellery did exist, and it was dealt with initially, as Mr. Varma says, he would then have had to reconsider each of the other points made about documents said to support the account. And if he's found that the jewellery didn't exist, it's a fairly easy conclusion to reach that a document that refers to the jewellery must be manufactured. If, on the other hand, one starting from the premise that it did exist and it was transferred in a way that produced £2 million odd, then the existence of a document saying the jewellery has been transferred becomes less suspect. Well, can I just give your lordships and your ladyship some references without taking you to them for later? In relation to the diamond ring and the culture, the references are in Supplemental Bundle 2 at tab 28, pages 473, and it's paragraphs 101, 102, 109 and 110.
Sorry, say again, what? 101, 102?
101, 102, 109 and 110. That's where His Honour Judge Prentice finds that the culture was challenged, but he finds it to be true. The diamond ring is an example, and paragraph 110 is this, as is the jewellery.
I'm so sorry. Supplemental Bundle 2, tab what?
28.
Thank you, that's fine.
And it's page 473 over to page 474.
Thank you.
And in connection with the existence of the jewellery or otherwise, in my submission, there's always been a slight tension in the way in which the respondent's case has been put in these matters. Because the respondent's case before Judge Prentice was that the jewellery did in fact exist, and that Mr. Kadka retained the jewellery after it had been given to him. The references to that are the amended points of claim, Supplemental Bundle 1, tab 9, page B267.
Can't be B267, I don't think, because the amended points of claim end at B251, at least they do in my book.
Sorry, I meant to say 226.
226.
My apologies, my lord. Tab 9, 2267. One sees paragraph 27 is the breach, a breach alleged against Mr. Varma.
Yes.
Yeah. And
27.2 rather hedges their bets, doesn't it?
well, it does a bit, and of course they're entitled to, in their own words, they're strangers to the transaction, so they are entitled to do that. But can I ask your lordship then to look at B230? 230, same document.
Yeah.
If the diamonds exist, paragraph 35, if the Dubai diamonds exist, they are currently in Mr. Kadka's possession or control. And then in 43, over the page, matters become perhaps slightly less hedged. In breach of fiduciary duty or in breach of trust and his obligation to deliver up company property to the claimants, Mr. Kadka has wrongfully retained the Dubai diamonds and or realised their value. Now, and that was the basis upon which the respondent secured judgment against Mr. Kadka. Now, they can't, well, I said they can't, and it seems slightly odd for them to ask for judgment on the basis that a man is in breach of his fiduciary duties because he has retained wrongfully the diamonds or their value, while at the same time saying these diamonds never existed. Or if they did exist, they were never transferred to him. It's simply another matter which we say shows that the existence of the diamonds was, it's not outlandish. And although my client wasn't able to take this over the line on his own, with the additional witnesses, he should have been.
Well, and also they assert the company's ownership of the diamonds, which can only arise if the sale of the diamonds from FZE to Grosvenor had actually taken place.
Well, my lady, yes. Of course, they're entitled to say if the diamonds existed, and they can hedge it in that way. But
it would have been a breach of fiduciary duty. I think you would have to accept for Mr. Varma to use Grosvenor's money or cause Grosvenor to buy the diamonds, because that was not what its business was supposed to be.
I was waiting for your ladyship to finish before
well,
I quibble.
So I think you accept that they're entitled to pursue both the diamonds and the £3.1 million. If in an extraordinary turn of events they manage to recover both the jewellery and the purchase price, then they couldn't retain both. There'd have to be some kind of reconciliation, but they're not in that happy position. At the moment they've got presumably neither.
That's right.
Milady, yeah.
Whether or not the actual sale of the diamonds, assuming that there was a sale, was a breach of fiduciary duty, is perhaps slightly nuanced as to whether or not it was a proper use of the company's money in the circumstances. But there would certainly be a respectable case to make that would be a breach of duty. I accept that entirely. As to the issue of what happens if the jewellery magically appears now, in the skeleton argument expressly states that credit will be given if it actually appears, although it hasn't. But the Judge Prentice found that the applicant had sold the jewellery and that Mr. Kadka was retaining it. And that's, if I give your court the reference, that's Supplemental Bundle 2, tab 28, pages 465 to 70.
Just before we go there, could you just clarify something for me? What was the claim which was purportedly being settled?
Well, my lord, in the settlement agreement that was signed, my lord, I'm not able to provide a coherent explanation for whatever claim was being signed. That is one of the documents that is inherently difficult to understand and therefore, from a lawyer's point of view, unsatisfactory.
Because I think Judge Prentice found that there was no money in the company account at the time that Mr. Ricardo was appointed as a director. He says that at paragraph 70. No money left.
Yes.
So it can't have been a straight sale, purchase, because there wasn't any money.
Well, it can't have been a straight sale and purchase. It can have been an agreement to buy and an agreement to pay later. But yes, I understand what your lordship says. But my lord, at paragraph...
You were taking us to pages 465 to 470.
I was, which is where Judge Prentice deals with the claim against Mr. Kadka as it was presented against him, and he deals with the jewellery. And then it's paragraph 73, he says, on the face of it, the company has bought, if not yet paid for the jewellery, which is held on trust for it by the first or third respondents at the home of the first respondent's parents.
But it's slightly odd, this section of the judgment, isn't it? Because in 72 he talks about a purported letter from Mr. Singh, but at 63 he's found that Mr. Singh probably never existed and certainly performed no relevant role. So what's this letter that he's referring to? How does that fit in with his previous finding that Mr. Singh certainly, his word, performed no necessary role within these events? So when he comes to say on the face of it, the company has bought, how do you tie that in with his finding that Mr. Singh certainly performed no necessary role?
Well, look, I assume that what the judge is referring to is on the face of the document,
Right.
but not actually saying that that's the.
So
that's
it's not a finding. It's just
not in.
No.
Well, no, your lordship is right. It's not a finding. It's a recording of what the document shows.
yeah, because he does it again at 75. He talks about a purported letter from Mr. Singh to your client.
Yes.
But he's already found that Mr. Singh certainly played no role.
Yes, he has.
But the document referred to at 73, well, 73 relies on the invoice.
Yes.
And then, which is the sale, and then the trust holding is the result of the letter from Mr. Singh saying, please hold, please could effectively...
All of the jewels and diamonds.
Please could FZE hold the jewellery on trust for Grosvenor,
No.
is what he's saying.
Yes. And then in 75, as my lord has indicated, there's another letter dated the 9th of June 2018, which purports to instruct that the diamonds be handed over to Mr. Kadka. And then 77 is the settlement agreement, which raises more questions than it answers, per Deputy Judge Agnello and Judge Prentice. And then
But the purpose of the settlement agreement was to release Grosvenor from having to pay any remaining balance of the purchase price for the diamonds. Wasn't it?
well, milady, that's one way in which it can be viewed. It's not entirely clear what the settlement was actually releasing on its face. But that may well be what the document is doing. The position is difficult because, well, it's difficult because we don't have evidence from the person who was responsible for signing it.
Who is that then?
That would be Mr. Kadka. He's the one who apparently signed it on behalf of the company.
On behalf of Grosvenor?
Yes.
And then you've got Mr. Kadka saying in paragraph 81 that he's liquidated the jewellery.
Yes.
So the judge says liquid assets represent the sold jewellery. And then at 85 he says he's got the jewellery. And as the judge says, they can't both be true.
Yes.
See, end of paragraph 87. And in effect, what he's doing in 88 is he's giving judgment against Mr. Carter on his own admissions, isn't he? He's not really finding anything. He's saying, well, it can't all be true.
Well, he's saying they can't both be true, but one of them's true.
Well, is he?
Well, he can't be giving judgment on the basis that neither is true.
No.
Unless he says, unless he were to, well, he shouldn't be giving judgment on the basis that neither is true, unless he sets out in his judgment why he's doing that.
Well, what is his reason? I mean, as I read it, he's saying, well, I'm going to take Mr. Cadker's evidence most strongly against him. So which of the two stories is most strongly against him? Well, it's the one that he holds he has got the jewellery, so that's the one I
yes. Well,
give judgment on.
Well, he finds you've either got the jewellery or you've got its proceeds, and there isn't any real difference as far as the company is concerned. If the jewellery still exists as jewellery, that's what the company is entitled to. If on the other hand it's being liquidated, then the proceeds are what the company is entitled to. But the company,
Mr. Cadker's evidence now, the evidence that you want to admit, is still that he's got the actual jewellery, isn't it?
it is, my lady, yes.
And what was, just remind me, sorry, I don't want to take you out of your course, but just remind me, not necessarily going to it, what was the order that Judge Prentice made as against Mr. Cadker?
I'm not sure. I'll have to find out in the bundle. My apologies, my lady. Mr. Brown's going to assist.
Okay.
I'm not sure it appears in the bundle, my lady, but I can assist by saying that the best Judge Prentice could do in the circumstances was do what my Lord Justice Lewison has suggested, and attribute the value of the claim to what Mr. Cadker had said it was, which was by reference to the invoice, which was subsequently found to have no credibility whatsoever, but the figure in that was 4.95 million. So that was the basis for the substantive judgment against Mr. Cadker. So the order was made with that plus interest.
So he didn't order the delivery up of the jewellery?
No, and one of the things that I said to the court at the time was that that's pretty pointless in any event, because the order of Mr. Justice Burse was that all company property that Mr. Cadker had, my lady, be delivered up by him. And that's because he evaporated in April 2019, just after he said what he says now, which is that he has the diamond.
I'm grateful. So what the liquidators got was a judgment based upon the findings that Mr. Cadker either had or had the jewellery.
On his own evidence?
Yes. But, well, on his own evidence, but the liquidators did not say to the court, you should not believe that evidence, you should not give us judgment because the jewellery did not exist and was not given to them.
Nor did Mr. Cadker say, or anybody say, the liquidators have previously maintained that this is all a fabrication, so how can they now be bringing a claim against Mr. Cadker?
Well, that's correct, my lady, but there was no one there whom it would have assisted to say that. My client wasn't a party to the proceedings in front of Judge Prentice.
It would have assisted Mr. Cadker.
Well, Mr. Cadker wasn't there. Mr. Cadker was absent. He had, by that stage, as my friends picturesquely put it, evaporated. So, had there been a represented party there to whom it made a difference, one might have expected the argument made, well, you can't eat your cake and have it. You must elect which scenario you want your judgment under, and that may or may not have certain consequences. But it can't hinder my client now, because my client wasn't there. And it's by no means, well, one assumes that Mr. Varma's son's legal team had access to Deputy Judge Agnello's judgment. In fact, they must have had, because it's referred to. so they would have seen what had been said by her, but presumably it didn't bother them that there were going to be findings made that the jewellery existed, because that fed into their own case, which was that the jewellery did indeed exist, and that the money that had been paid to the son was the proceeds of that jewellery.
But it was paid in April 2017, or in August 2017, before Mr. Carter was appointed as a director, before he claims to have inspected the jewellery at Mr. Varda's deceased mother's house in Mumbai, at a time when there was no money in the company. The money had already gone to the son.
Well, my lord, yes, none of that I can contest on the basis of the evidence that's being given. But those are issues that feed into the question of whether or not subsequent transactions give rise to a finding of a contempt of court. And of course, there's the issue of whether or not there has been a fraud or some misappropriation of company assets. There's the separate issue of whether or not my client should be found to have breached the order and therefore be in contempt of court. But as I said to Lordship once before, and I may be saying again before I sit down, there is scope for questioning of sequences and inconsistencies all over this case. The question is whether or not this new evidence would credibly have a sufficient influence on the mind of the fact finder. The decision would be other than, I am satisfied so that I am sure that there has been a breach of the order, and might simply be, I'm no longer sure.
Do you submit that Judge Prentice should have declined to give judgments against Mr. Vodka?
Well, I was about to say I was agnostic on the point, but that would be wrong. I don't make any submission that he was wrong to do that. It strikes me as, well, no, he's not wrong to do that, because
on the admissions.
On the admissions, he was entitled to do that. Mr. Kadkar was absent through a deliberate decision, and the evidence included those admissions, and he was entitled to give the judgment on it.
And it doesn't disadvantage your client?
No, it doesn't disadvantage my client. That's why I thought I might be agnostic. I decided I wouldn't be, because it does assist my client, because to the extent that we're dealing with res judicata, although I'm reluctant to go down that road in the context of this appeal, it just shows more evidence that the jewellery did exist.
But it assists your client in that it enables you to stand up today and say there are inconsistent findings. But that's why I phrased my question as I did. What else should Judge Prentice have done when confronted by Mr. Vodka admitting that saying that he had the diamonds?
Well, Laura, I don't say that Judge Prentice had a problem with inconsistent findings here. It would be wrong to suggest that it is a distinct ground of appeal to say that there was a later judge who took a different view on the same issue because he heard different evidence. Therefore, the first judge was wrong, because that simply misses the point. His Honour Judge Johns made findings on the evidence he heard. The question is whether or not, because His Honour Judge Johns did not have evidence that was available, but wasn't available to my client, he should have reached a different conclusion, or might have reached a different conclusion if he'd had all the evidence. The only reason, the issue of incompatible judgments is the way it's put in the skeleton argument, which secured permission to appeal. The judgments are incompatible, on that at least the parties are agreed. The question is, what is the significance of that incompatibility? I say it's an evidential matter, because it shows that the evidence that I wish to have admitted is credible because it has been believed on the issues that we say it bears in relation to the jewellery. The response of the respondents is to say, well, it's a full-throated attack on Judge Prentice's decision. based on res judicata, and also an attack on his failure to properly assess the credibility of the witnesses. And that faces the hurdle that ground 2 failed to cross in this appeal.
Yeah.
It's inherently unlikely to prevail. In relation to the res judicata point, it seems inherently difficult to argue that that my client's son was barred from proving that the jewellery did in fact exist simply because Deputy Judge Agnello reached the conclusion in proceedings, in a hearing to which he was not a party and had no right of audience, decided that it probably didn't exist. Especially bearing in, well, and although it, technically the res arises even on a default judgment, there was no contested argument on the points because of my client's state as a debarred defendant.
Yeah.
And the suggestion that His Honour Judge Prentice would be unable to make that finding because of a finding of His Honour Judge Johns it's close to bizarre, bearing in mind that none of the other litigants would have had a right to attend and make an argument in front of His Honour Judge Johns. And if that was an outcome that was contemplated when the committal hearing was being scheduled, one would have expected it would have been raised with the other respondents to the litigation. And they would then have had the option to attend, make argument, cross-examine, give their own evidence. Strikes one as a prospect that should be most assiduously avoided. The suggestion that it's a res as a result of what His Honour Judge Johns found, which bound the son, strikes me as inherently unattractive, but irrelevant, because what matters is not whether or not...
nor bind Mr. Cadcar.
No, it couldn't bind anybody other than my client.
Yeah.
Because, well, I'm not going to repeat it, but the point, see, that with respect to my learned friend, the point to me seems obvious. And there may be a technical way in which you can say it's all one set of proceedings and therefore. But when one steps back and looks at it in the round, it simply can't be right to say that if in a committal proceeding someone is found not to have done something or something is done, it can't possibly bind at the final trial as regards other parties. And I, in my skeleton argument, I drew the inference that no submissions had been made to Judge Prentice on the res issue because it wasn't in his judgment. My learned friends have been good enough to furnish me with a copy of their closing submissions to him. And it's right to say that the impact of Deputy Judge Agnello's judgment is raised under the heading of res judicata. But it is not put in those submissions on the basis that anything that Deputy Judge Agnello found in relation to whether the jewellery existed or had been sold operated as a res. And that was entirely sensible.
Yeah.
There is a reference to the fact that her finding in relation to one of the documents as being a forgery might be a res. But even those submissions are properly tempered by the fact that new evidence is now available. So it's raised, but it wasn't said in terms to Judge Prentice, because Deputy Judge Agnello made this finding, you can't find anything other than. So, but as I say, I'm reluctant, having gone down that road, I'm reluctant to stay down it very much longer because it isn't the point here.
No.
It isn't the point.
The point is, you say, look at this evidence, it convinced Judge Prentice, if it had been before Judge Johns, then it might have persuaded him that there was a reasonable doubt that the statement that the jewellery didn't exist was false.
Yes, and that it had been dealt with in the first instance, the way in which my client said it.
Do we actually have your client's statement? The charge against him was he knowingly made a false statement in his affidavit of the 16th of May 2019, but I'm not aware that we've got that. Have we? Perhaps I've just missed it.
I'm not sure that your lordship does.
Should we not have it if we are going to consider this? I mean,
well, my lord, I'm sorry.
All we know about the statement is what Judge Johns says about it in paragraph 39 of his judgment. He says the alleged false statement is a statement of in his affidavit of the 16th of May 2019 that the funds of approximately £3.1 million paid to GCFSE, quote, were paid against sale of jewellery and diamonds to the company, unquote. That's all we know about it.
Well, Lord, yes. And the reason it's set up because that was the falsity that was being attacked. And if the jewellery didn't exist, then it was difficult to see how that would otherwise.
Well, I follow that, but if the jewellery did exist, but it wasn't sold to the company, it was sold before the company came on the scene and its proceeds passed to your client's son, that would also be false.
Well, Lord, that would be right. And that's why.
Should we not see what it? I mean, he must have said more than half a sentence,
Well,
mustn't he?
Well, Lord, he must have said more than half a sentence. I don't have that statement immediately to hand, and
Well,
I'm not sure
perhaps you could, or Mr. Brown could arrange for us to have it, or at least the relevant part of it that deals with this sale.
My Lord, and of course.
Can I just expand on that? I think it would be useful to have that, and then a note of where in the bundle we find the actual allegation of contempt, how that was formulated in the committal application, and what was said in the evidence in support application was the actual falsity that was being found. I don't necessarily want it now, but I think that to follow that path to the finding of contempt, I think is an important part.
Well, I can assist your ladyship with some of that. The affidavit in support of the application for committal is in the core bundle at tab 10.1. And at core bundle page 271.21, I think it's section C. Apologies. Well, it's actually 271.23, where it deals with paragraph 90.3 deals with the diamonds. But I'm on my feet. I'm not able to give your ladyship the precision your ladyship is asking for, so I'll stop confusing on that and make sure that myself and my learned friends are able to give the court an agreed trail. Can I at this stage touch upon the issue of disclosure of these documents, bearing in mind that grounds 4 and 5, as I said at the outset, appear to overlap to a very large extent. I do not seek to argue that the Attorney General guidelines apply to contempt proceedings. In my submission, I don't need to. Can I ask your lordships and your ladyship to look briefly in the authorities bundle? Two of the cases. The first is one of the many Ableazol hearings. It's at tab 8 in the authorities bundle, which is page 106. And it's this is Mr. Justice Tier, paragraph 12 on page 109. Headed disclosure. And there was a debate as to what, if any, duty of disclosure the bank had in the context of the contempt applications. The bank submitted it had none, relying upon Masri. but said that in any event it did not have any documents which damaged this case or assisted the case that Mr. Abbey resolved, that the only assets he beneficially owns which are valued at more than 10,000 of those he is ready to disclose, beyond those that had been disclosed in various states. It seems to me that if the bank has a document which damages its case on the contempt allegations or assists Mr. Abbey's case, fairness requires that such document be disclosed. There would not be a fair trial if the bank were able to make submissions that there has been a contempt for which he may be imprisoned without disclosing a document which damaged his case or assisted Mr. Abdezol's case. I do not think that anything said by Mr. Justice David Sealing invalidates that position, and he therefore made an order. If I then ask the court to turn to tab 12 in the authorities bundle, which is the Navigator case, Mr. Justice Andrew Baker, this summer, and section which begins at page 260 of the bundle, paragraph 138. It's headed quasi-prosecution. And paragraph 138 deals with the need to ensure that there's a proper purpose, which isn't relevant to this appeal. And then over the page, we get to paragraph 141. Contempt proceedings of particular and distinctive character, civil proceedings, but bear several important hallmarks of criminal proceedings. They've been described, I think, aptly as quasi-criminal in character. The hearing is not to be equated with a criminal trial, not to be equated with a private prosecution, but the quasi-criminal character of this particular species of civil litigation has important consequences. So it's not the label that matters, it's the substance of what's going on that is important. Paragraph 143, 142 doesn't bear on the issues we're discussing. Further consequence is that the claimant charge as much as a quasi-prosecutor serving the public interest as it does as private litigant pursuing its own interests in the underlying dispute. The claimant applicant needs to understand that, and if it is legally represented, as here, the legal representatives need to understand that their role as officers of the court is acutely pertinent, even if, to repeat, the process is not to be equated with a private prosecution in a criminal court. Thus, it appears to strike Mr. Justice Taylor as obvious in the long-running abuse of litigation that the quasi-prosecutorial role in pursuing a contempt charge means its proper function is to act generally dispassionately, to present the facts fairly and with balance, and let those facts speak for themselves, assisting the court to make a fair quasi-criminal judgment. And then it's right that I should read on, because it may be said that those remarks need to be qualified. I agree that it should be the approach at all events in a case like the present, which is all that matters to this judgment, where any private litigation interest the claimants may have had in the enforcement of the undertakings was spent before they launched their committal application. Now, I have to accept that this is a different case, because unlike that case, the private litigation interests of the respondents to this appeal survive. So it wouldn't be right to simply stop at the end of 143. But I do say that even though the private rights of the respondents continue to on how this litigation and the application to commit should be conducted, if one is considering what fairness requires when a person is at risk of imprisonment, the fact that the party pursuing the contempt charge still has a private law interest cannot possibly render it fair for it not to disclose what I'm going to term as known adverse documents. I say that whilst the last three lines of page 143 may need some qualification where the private law interest survives, it's still the proper function of someone who is pursuing a contempt charge to act generally dispassionately, or certainly less passionately than they would do in civil litigation in the general run.
Well, the liquidators here are officers of the court.
Well, milady, yes. But milady, well, and obviously that is right, and it carries with it certain responsibilities. But I think, in my submission, Mr. Justice Andrew Baker was assuming that everybody that this touched upon was an officer of the court or counsel. So that really doesn't assist me any further. It's simply a case of saying, even if you've got a private law interest still in pursuing this contempt, because, for example, you hope to flush out the diamonds, it doesn't mean to say that you no longer act as if this is just another part of the litigation. You have to moderate your conduct, you have to moderate the tone, and you do have to be particularly careful about fairness. And in this case, it is no part of my submissions to this court that anyone on the respondent's side has been guilty of any improper conduct. The references to conditional fee litigation, the court will be aware of conflicts that can give rise to. I make no submissions on that. It's not necessary for the proper disposal of this appeal. But what I do say is, if one is looking at the fairness of the proceedings, the question has to be asked, why would the court not expect someone seeking to have someone committed to prison to disclose documents which on their face would assist that person in defending himself? And let those documents speak for themselves in front of the fact-finding tribunal.
Yeah. Those documents are the witness statements of your client's son, ex-wife, son's partner,
and the grandmother.
And the grandmother.
Indeed.
But not Mr. Carter, whose statement came later.
Not Mr. Carter, whose statement came later. And this doesn't apply either to either of the
son, the ex-wife, the son's partner.
I think yes, and the son and the maternal grandmother.
Yeah.
Yes.
So that's
maternal. The paternal grandparents were the ones from whom the cache of jewellery had come and who were deceased. The maternal grandmother was the one who provided the single large ring.
Yeah.
Culture. So, and it's really the son and the ex-wife. The other two are relevant but less crucial.
Yeah.
But in my submission, when those witness statements arrived on the
that was the 3.1.2 that you
indeed. Well, we infer that.
Presumably Mr. Brown will be able to tell us.
If I'm wrong, I'll be politely corrected. I've assumed that because we know from the chronology that the trial of the son's action started about the next week, because that's from the cross-examination that I took your lordship and your ladyship to earlier on. So these are witness statements coming up hard against a deadline. So in the language of the disclosure pilot, these are known adverse documents, and there's an obligation to disclose those at any time without any order. So the argument about whether or not Part 31 applies to the application, whether or not there needs to be Attorney General's guidelines or anything else, really falls away, because what the court is concerned with is the issue of substantial fairness.
Yeah.
I understand you make a more general point, but is this a case to which the pilot applies?
Well, Lord, in my submission it does, because it's within the Business and Property Court, it's existing proceedings, and the pilot's been in operation for long enough for this to apply. But if it doesn't, it should.
Well,
I understand what you're well, the matter isn't addressed in the standard texts. The weight of what is in the standard text suggests, and it's supported by cases in the bundle, that it's for the respondent to a committal application to ask for a disclosure order, and that a disclosure order will be dealt with on conventional Part 31 terms, specific disclosure. And we see that from various cases. If you ask for focused disclosure, you're likely to get it. If you ask for a huge fishing expedition, you won't. So conventional disclosure. Those cases predate the disclosure pilot. And in my submission, the disclosure pilot imposes upon parties, without any order, the obligation to disclose known adverse documents. It's paragraph 3.2.
But normally, if it is thought that the disclosure pilot applies, then one expects to see somewhere in an order, a case management order of some kind saying just that.
Well, your lordship's expectation. Well, if one gets to a case management conference, that may well be right. One may not see it expressly, but one would see it by implication, because one would see lists of issues for disclosure and various other steps. I with all hesitation, I've not seen an order which simply says the disclosure pilot applies to this, but then my experience is far less than your lordship's. But whether or not one would only have seen it if there had been an interim order made in this case, and it might have been there. But whether or not an order was made saying it applies isn't the issue. It's does it apply, and its proceedings in the business and property courts.
But then you've got a fallback position, which is even if it doesn't,
well,
the principle should apply on the basis of
yes,
facts.
and the question has to be, why wouldn't a person pursuing a contempt charge, adopting the appropriate degree of dispassionate fairness, even allowing for continuing private law rights, not be required to do this? If the case is true that the party is pursuing, it will still prevail. If it isn't, then it shouldn't be pursued. And to the extent that, and this, there will be an echo of this again in the argument on ground 3, to the extent that this puts an additional burden on the party bringing a charge of contempt, and may in fact result in fewer charges being brought, my response to that is, well, that's no bad thing. Charges of contempt should be relatively rare. They should only be brought where the overall evidence merits it. And if the evidence changes, because, as in this case, we say it did, as John Maynard Keynes said, when the facts change, I change my mind. What do you do? There has to be a continuing process of review. Can I just make one further point on this? In addition to the witness statements, the amended points of defence of the son were not in the bundle before His Honour Judge Johns. And it was those amended points of defence that pleaded the case that was then evidenced in the witness statements on behalf of the son. That was an oversight on the part of those who were pursuing the contempt charge. That's the way it's explained in the skeleton argument, and I'm happy to take that at face value. These things happen. But what it means is that the son's case, as it was known to have been pleaded at the time of the contempt trial, wasn't there to be seen on the face of the documents.
Right. Is there anything you want to draw our attention to in that pleading? The son's case was, as I understand it, I got this money, I thought it was from my father, I didn't know there was anything wrong with it, so I trusted my father, and I went off to some solicitors and signed a deed of gift, and that's all I know about it. Therefore, my retention of this money is not unconscionable,
Yes.
wherever it came from.
Yes, but he did say that he believed it had come from the jewellery inheritance. That
A year before the alleged sale.
Well, the pleading is in Supplemental Bundle 1.
Yep.
Which is it's tab 10, and the relevant part is at page 258. And it's paragraphs 32 onward. And paragraph 33, Mr. Varma Jr.'s account in relation to his receipt of the sum is set out below, and there's then reference to the grandmother, the telephone call in mid-17, saying that basically the living inheritance, if one calls it that.
Yeah.
So your
client got the jewellery, and that enabled him in August 2017 to transfer £2 million in cash.
Well, yes. Well, yes, and again, as I predicted I might have to, I say there are inconsistencies everywhere. But the fact that the jewellery had produced the money was there on the face of his pleading. Well, look, that's all I intend to say in relation to that evidential category. And I'll take the second more shortly. It's Mani Singh. And these are the witness statements of two solicitors who give evidence that Mr. Singh existed. And Mr. Needle gives evidence that he certified a copy of a gentleman's passport, and that he only ever does that if he has someone standing in front of them who matches the photograph on the passport.
But does it matter whether Mr. Singh does or doesn't exist? You've got two findings that even if he does, he played no part in the company.
Well,
you've got the finding of Judge Johns, and you've got the exact same finding from ICC Judge Prentice.
Well, of course, unlike the topic we've just been dealing with, this evidence didn't go in front of Judge Prentice. So this is
no.
evidence. So that the finding of Judge Prentice doesn't add any weight to the finding of His Honour Judge Johns, because it was made without the evidence might tip the balance.
Yeah.
But your Lordship is right to say. Your Lordship is right to say that Your Lordship is right to say that it was decided not only that he didn't exist, but if in the alternative, if he did exist, there was no evidence he'd been involved. The point I make there is, once one's decided he doesn't exist, it becomes relatively easy to say, if he did exist, he wasn't there, because
What evidence do you say there was that he was involved?
Well, the evidence is the evidence of my client saying, I spoke to him and he told me to do these things. Now, of course, if one is approaching that evidence on its own, against the background of no documentary evidence that he even existed, so that a judge says, well, I'm quite satisfied Mr. Mandeep Singh didn't exist, then my client's evidence becomes effectively worthless, particularly as in the same hearing and as part of the same process of fact-finding, it's been decided he's lied about the existence of the jewellery.
Yeah. I think in fairness to yourself, Mr. Carter also says that Mr. Singh gave him some instructions.
Yes.
It was Mr. England who mostly said that he got instructions from Mr. Singh about paying out all this money, and the Judge Prentice disbelieved that.
Well, the problem in relying upon anything Mr. England said is that Mr. England didn't attend to give evidence. What we didn't have was anyone actually in front of Judge Prentice saying, yes, he existed, and the same was true in front of His Honour Judge Johns. My client was saying it, other people had written it was in pleaded cases, but there was no documentary evidence, certainly nothing that could certainly come close to a certified passport, certified by...
Well, it depends what we mean by Mr. Singh existing. It may not be surprising that there is somebody out there who has a passport giving their name as Mandeep Singh. So it's not surprising that there is someone with that name whose passport has been certified at some stage for some purpose by a solicitor. I don't think that's necessarily what the judges meant when they said he doesn't exist. They weren't saying there's nobody in India with that name with a passport.
No, that would have been a rather sweeping statement.
Yeah. What they're saying is it's not really anything different from he was not involved in the way that is being described.
Well, milady,
or is it?
Well, milady, it's not what His Honour Judge Johns said. If he'd said he may well exist, but he's not involved, that would be one way of putting it. But he went slightly further. The way in which I fully accept that producing a passport which bears the name Mandeep Singh proves that there is someone called Mandeep Singh, and that's not what we're talking about. But the person who certifies the copy certifies that Mr. Needle certifies the passport. Mr. Williams gives evidence about his contact with Mandeep Singh in a context which involves my client. So we're not simply saying there's someone called Mandeep Singh, here's his passport. We're saying here's someone called Mandeep Singh, here's his passport, and here's the evidence of Mr. Williams, who provides a link between Mandeep Singh and my client.
But Judge Johns' words are quite carefully chosen. What he says at paragraph 45 is not that Mr. Singh doesn't exist, therefore he wasn't involved. He puts it the other way around. The evidence overall does not support the involvement or even the existence of such a person. So his first point is there's not sufficient evidence of involvement.
Well, my lord, I accept that's the sequencing in the finding. And it may be slightly artificial to say, well, that means he's found first he wasn't involved and secondly he didn't exist. It seems, well, your lordship has a better insight into the judicial mind than I. Well, my submission is, if you've got both those findings in the one sentence, it's unduly artificial to regard it in the way that your lordship is using it. But that's, I accept that that area of evidence is less likely to be fertile ground for me.
Right.
So, my lord, if I can I'm just checking. I believe that I've covered all that I want to cover in relation to new evidence and in relation to grounds 4 and 5. Your lordship and your ladyship have the further skeleton argument which sets out the specific references within Judge Prentice's judgment on which I rely.
If you succeed on one or both of those grounds, what is the result? What is it that you're asking us to do?
In my submission, your lordships and your ladyship will allow the appeal, remit the matter for a new hearing.
Presumably to a judge other than Judge Johns, who has already formed views about
Yes,
ability.
that would have to be the result. If I then move on to ground 3, I apologise. I didn't formally inform the court that I was not pursuing ground 1 or seeking to renew ground 2, but I imagine the message had got through. In relation to ground 3, which subdivides into findings 3 and 4, which deal with the question of whether it is necessary to prove an intention to breach the order or not. I need the court's permission to address you on this, as it's certainly not properly set out in the initial skeleton. May I proceed on the basis that you'll hear me and then decide whether or not I have permission? There is clearly a divergence of authority on the issue of whether or not it's enough to prove that an order was breached, or whether or not the party charged with the intent intended to breach. And by that I do not mean that the act which resulted in the breach was accidental or casual in the epithet that's given, but whether or not there was an intention to actually breach the order. And I accept that the weight of authority is against the proposition that I put forward. And if the court has looked at Arledge on contempt, or even read what's been said about that in the skeleton argument, you'll see that Italian Squatriti gets its own little chapter, a case of doubtful authority. It seems, in my submission, to have survived being doubtful because of the constitution of the court concerned. I have to accept that it is a case that was argued on one side only, which is never a particularly good start. And the citation of authority to that court might have been fuller. It may also be, well, I was going to say it may also be thought that the decision might have been obiter, but that clearly wouldn't be right in the circumstances.
I think there's a case in which Mr. Justice Newberger, sitting at first instance, refused to follow it.
Well, there are a number of authorities in which that's happened. I think there are 3 which I've referred to in the skeleton argument. We have Mr. Justice Newberger having declined to follow it. We have Mr. Justice Jacob having and we have Mr. Justice Christopher Clark. So we have 3 judges sitting at first instance, and who then progressed further, all of whom declined to follow it on the basis that there was a conflict, but on the basis that there was the subsequent affirmation of Stancombe's case in the Pioneer Concrete case in the House of Lords. And it was decided that it was inappropriate to choose a single Court of Appeal decision over the implied endorsement in the House of Lords of Stancombe's case. However, Mr. Justice Jacob did observe that had he been free of authority, he would have chosen to follow Irtelli on the basis that he thought it was the better decision. Can I ask the court to go to the Masri? If I just, because it contains a passage which it's Masri at tab 25 of the bundle. And it's paragraph 150 onwards of page 469 of the bundle. This is Mr. Justice Christopher Clark's judgment, and in which he collects the various other cases in which the point has been raised. And we see at 150 we have the heading mens rea, and we have then the traditional three tests: knew the terms of the order, acted in a manner which involved a breach, knew the facts which made conduct a breach. No doubt, in this present case, judgment debtors have at all times been fully aware of the orders. Couldn't be sensibly suggested the conduct was casual, accidental, or unintentional. The question arises whether it's also necessary to show they acted knowing what they were doing was a breach. And then there's reference to Stancombe. If a person or corporation is restrained from doing a particular act, that person commits a breach of the injunction liable for process. If he or she does the act, then there's no answer to say the act was not contumacious, in the sense that in doing it there was no direct intention to disobey the order. I think the expression willfully in order 62 is intended to exclude only such casual or accidental or unintentional acts. So that is the conventional approach. And then there's reference in paragraph 152 to the Adam Phones Limited case, which is Mr. Justice Jacob, who identified the two opposing lines of authority, Heaton's Mileage Conference and Spectre Vest on the one hand and Irtelli on the other. Former cases hold that there is a contempt of an act intentionally done amounts to a breach of the order. In the latter case, Court of Appeal said that it was necessary to show contumaciousness. In that case, where committal to prison was sought, the defence had done that which was a breach of the order, the creation of a further charge, but had produced some not particularly convincing evidence that they did not understand the order to preclude it. And since that evidence was not challenged, the court concluded there was no knowing breach of the order. I'll take your lordships and your ladyship back to the case briefly soon to make good that. Mr. Justice Jacob said that free from authority, he would have sided with Irtelli, but felt bound to follow the earlier cases, of which Heaton's was a decision in the Court of Appeal, in the House of Lords, particularly when Arledge described Irtelli as a doubtful case, and when the House of Lords and the Director General of Fair Trading and Pioneer Concrete had approved of what Mr. Justice Warrington had said in Stancombe, and said that it should be followed in that case. Then there's reference to Bird and Atkinson, which is the case involving Mr. Justice Neuberger, who also declined to follow Irtelli. But in my submission, we see in what follows part of the problem that refusing to modify the approach can lead to. In that case, he had to first determine whether or not an obligation to give information about what had happened to various sons required that the information be accurate. He held that, at least on the face of it, an inaccurate answer did not comply with the terms of the order, but said that if an inaccurate answer was given in good faith and after all reasonable inquiries, it would either be a contempt of the most technical nature, or there may be no contempt at all. As for the clash of authorities, he regarded himself as bound not to follow Irtelli, again having regard to Pioneer Concrete, and the remarks of Lord Wilberforce that liability for contempt does not require any direct intention on the part of the employer to disobey the order. He observed in Irtelli the previous line of authority had not been cited, and that the case had been cited without opposition. The case had been decided without opposition, my apologies, and that what had been cited was Pioneer in the Court of Appeal, which the House had subsequently reversed, then I regard myself as similarly bound. I do so with less reluctance than Mr. Justice Jacob. In my judgment, the power of the court to ensure obedience to its orders for the benefit of those in whose favour they are made would be inappropriately curtailed if, in addition to having shown that a defendant had breached the order, it was also necessary to establish, and to the criminal standard, that he had done so in the belief that what he did was a breach of the order, particularly when a belief that it was not a breach may have rested on slenderest of foundations or on convenient advice, which was plainly wrong. So, in my submission, if irtele is not to be the preferred line of authority, we see already in the approach of Mr. Justice Neuberger, as he then was, the problem that will face judges, and already does face judges, when they are asked to adjudicate on contempt matters. If one looks at the second sentence in paragraph 154, Justice Neuberger held that, at least on the face of it, an inaccurate answer did not comply with the terms of the order. And that must be right. If the order says you must give an accurate account, and you don't, you're in breach of the order in terms of the fact. But he says it would either be a contempt of the most, if it was given in good faith and after all reasonable inquiries, it would either be a contempt of the most technical nature, and on that there's probably agreement amongst everybody in this court, or there may be no contempt at all. It's difficult in my submission to reconcile that proviso with the traditional approach to adjudicating upon whether there has been a contempt of court. Because even if one has made all reasonable inquiries and one believes one is providing answers that are accurate, if they are in fact accurate, you are doing something, in other words, giving an answer, which you know you are giving. It's not a casual or accidental slip, you're deliberately giving it, and it is wrong.
Yes, but it goes to the sentence.
Well, my lord, but
I mean, it's the same in criminal proceedings. You committing a crime.
Well,
you just need to know what you're doing and intend to do what you're doing. And if it turns out to be a crime, well, that's bad luck, but it can be reflected in the sentence.
my lord,
I mean, therein lies the huge difference between civil proceedings, where sometimes a particular intention is required, and criminal proceedings. Because if you're civilly liable for some tort, let's suppose, there's no power in the court to mitigate the damages awarded because you didn't realise that what you were doing was tortious. You just get the damages. Whereas in the criminal context, it goes to the sentence.
well, no, it would certainly go to the sentence.
Yeah.
But that's not what Mr. Justice Neuberger said. He said it would either be a contempt of the most technical nature, or there may be no contempt
Well, it's a
at
very
all.
tentative observation.
Well, it is, but it's an observation made by a judge then at first instance, looking up and seeing two possible courses and deciding that he is bound to take one on the basis of the cases before him. But in my submission, if one is going to even admit of the possibility that there may be no contempt, if someone tries in good faith to comply with an order but does not, one is already watering down the traditional approach. One is admitting the possibility that certain states of mind may avoid a finding of contempt. Now, whether or not it would have to be an out-and-out finding, you must prove an intention to defy, or whether it would be, you will have a defence if you take all reasonable steps, would be a matter for further consideration. The question, however, is there the bright line that says, regardless of your mental state, however blameless you might be, you are at risk of contempt proceedings if you do not factually comply with the order. With regard to paragraph 155, in my submission, there's less in the concerns of Mr. Justice Christopher Clark than might first appear. The court has many weapons in its armoury to enforce orders that are made, short of applying to commit someone to contempt of court. All of the other remedies will still be there. In a situation where a person is said to have breached the order. If the breach of the order is not intentional, if it is something that has happened even though a party has tried to comply with the order, has believed they've complied with the order, so less, has been advised how they should comply with the order, what is the public interest in exposing them to the risk of a period of imprisonment? I accept, of course, that it is practically inconceivable that any court would commit to prison someone if it thought there was any real doubt that they had acted believing that they were complying with the order, but as a matter of law, not. But the risks to that person would still be there. The person is put under the stress of being committed to prison, even though viewed objectively, they would have done nothing morally wrong at all. And in my submission, to say that judicial fact finders on a committal application would be unable to weed out the unmeritorious pleas of slender foundations or convenient advice is an unduly pessimistic approach to the issue. And in any event, it has to be weighed against the interests of those who face committal proceedings when they have not in fact intended to breach orders, but have done so through inadvertence or a lack of understanding or poor advice. In relation to the authorities, can I ask the court to look back first of all at Irtelli, which is in tab 23. Just very briefly to show the court the clarity of the judgments there. On page 402 of the bundle, at letter H, we have Lord Justice Farquharson. And this was another case where evidence was being sought to be introduced on appeal. Question for us is whether the evidence now available establishes beyond a reasonable doubt that they did intend to act in contempt of the court's authority. We are in some difficulty in resolving that matter for two reasons. That was the question. Did they intend to act in contempt of the court's authority? And then on page 404, we see Lord Justice Taylor at letter F. It's regrettable that the judge heard nothing from the appellant side, despite the fact that they were represented. No oral evidence, no affidavit evidence, not even an address in litigation. Had he heard the evidence now placed before us, he may not have been wholly convinced by it, but in my view he could not have been sure that the appellants had knowingly breached the court order.
What does that mean?
Well, whether or not doing what they did, whether they knew what they were doing was a breach of the court order. It was a case where a second charge was placed on a property, which was a breach of the order.
Yes.
The problem was, as far as the evidence that was being led by...
He'd been told that he wasn't to sell it, but he wasn't told that he couldn't charge it.
Indeed. And the evidence was, well, we were told we couldn't sell it, we weren't selling it.
Yeah.
And so it wasn't the most compelling of evidence, but it only went to whether they believed they were doing what they were prohibited from doing.
Because you must have known and intended to place the second charge.
Yes, it wasn't a casual or accidental act. And then at the bottom of page 404, very bottom of page 404, we have Sir Donald Nichols. On the material before him, he was entitled to conclude that the appellants must have known that the execution of the charge was in breach of the order. And then over the page at E, on 405, E, I agree that on the basis of the new evidence, the judge's order committing these two defendants to prison should be set aside. the affidavit evidence of the defendant is to the effect that they did not understand that executing a further charge was prohibited by the order. Like Lord Justices Taylor and Forbes, I do not find that evidence in all respects convincing. Raises almost as many questions as it answers, but it has not been challenged before us.
Sorry, I'm behind you. Where exactly are you?
Sorry, my apologies, my lord. I'm on page 405 of the bundle, at the concluding paragraph of Sir Donald Nicholl's judgment. Beginning, I agree that.
Yeah, thank you. And
then, accordingly, the conclusion has to be that a knowing breach of the order by the appellant has not been proved.
Can I think I'm behind everybody on this argument at the moment, so can I just see if there's a way that you can bring me up to speed quicker? If we go back to Mr. Justice Newberger's case,
My lord.
If what the order requires is that someone should provide accurate information, and in good faith they give evidence which proves to be inaccurate, what is it that they've done non-accidentally? Is it providing information or providing inaccurate information, and does it matter?
Well, what they've done without accident is provide the information that they provided. Because whether or not they provided accurate information is a matter that is objectively verifiable. Their non-accidental act is the provision of information. For example, I have no assets over £10,000. That's what they provided. And if it's not accurate, that's a breach of the order. Because if he says, well, the reason I did that is because I asked my accountant to tell me what assets I had, and he said, you've got nothing that's worth more than £10,000. He's providing that information. He's providing it in good faith on the basis of ostensibly reliable professional advice. But he's providing information which is inaccurate. Now, some of these problems can be addressed by drafting the order in a different way. So if the order says you are to provide your good faith assessment of your assets, having the benefit of sensible professional advice, then that would of course be an entirely different matter. But if the order is provide accurate information and you do not, then you will have breached. Now, of course, it would be possible, for example, for someone's finger on the keyboard to slip, and instead of typing 500, one type 200. That might be an accidental slip, and therefore would be saved. But if what one does is say, I intend to type 10,000 when I should have typed 50,000, you're in breach.
Thank you.
And in my submission, that's the natural concern of any judge, knowing that that sort of issue exposes someone to the risk of proceedings for contempt in what one would assume would be hard-fought litigation. Now, obviously, one would hope that if the appropriate degree of dispassionate, objective restraint is being used, one would not see that sort of application being brought. But in this case, we have findings of contempt made without any attempt to suggest that my client knew that what he was doing was a breach of the order. So by definition, my client stands in locus penitentiae in relation to acts which he did not realise were a breach of the order. That may, of course, there is the response, unspoken as yet, that, well, those aren't the matters that are going to result in the heaviest penalties, are they? And of course they won't. But that's not going to be, that's not an answer as to why, whether or not he should be labelled a contender for those acts at all. I don't know whether or not that brings your lordship roughly up to speed.
Well, catching, I hope, eventually.
Well, Lord...
Thank you.
Well,
that's fine.
Of course, whatever your lordships and your ladyship think of the merits of the arguments I put forward, there is still the problem to be addressed with authority.
Yeah.
And I have to accept that the Pioneer case in the House of Lords, familiar to at least one member of the court, endorses Stancombe, and to that extent is against me. Now, the way in which, and I should take your lordship to that.
Just before we leave telly, as far as I can tell, Mr. Wadsworth never argued that there was no breach. His argument, as recorded on page 397 of the bundle, between C and D, was that the breach was merely technical. Don't think he ever argues that there wasn't a breach at all. Unless I've missed something. So it's not just a case of there being only one side. The point doesn't seem to be argued at all.
I pause because that had escaped me, and your lordship is right. On the basis of the report, which one must assume accurately summarises the argument, it may well have been a matter that came down to counsel from the bench and would doubtless have been eagerly seized upon.
Yeah.
Although there may be some support for the contrary inference if one looks on page 396 to see the cases that were cited to the court in the skeleton argument, though not referred to in argument, because we see the last of the cases is the Pioneer case, albeit in the Court of Appeal. The outcome was the opposite to the House of Lords, and therefore would have been favourable, or at least not contrary to a submission, requiring some form of intention. So it may be that there's an absence in the argument. One doesn't know.
Right.
It's nice to know it's not just documents my client produces that may sometimes leave questions unanswered.
Yes.
If I can then take your lordships and your ladyship to the Pioneer Concrete case. I'm not going to try and summarise what it was about.
A long time ago, so don't ask me to summarise. I remember it very clearly, though.
So, and can I take your lordships to page 427 of the bundle? And we're dealing with one of the number of cases in which the liability of a corporation for the acts of its employees or agents, which acts were contempts, was being considered. And what we see here is Lord Nolan referring to Stancombe and Trowbridge, Mr. Justice Warrington. The defendants were restrained by an order of the court from sending sewage into a stream. As a term of the same order, they undertook to cleanse the stream, committed breaches of the order, failed to cleanse the stream in accordance with their undertaking. And then there's reference to Mr. Justice Warrington's judgment. And we've already looked at the first limb of that, which goes down as far as letter E. So I'm not going to read that again. The second limb of that doesn't concern us because that's dealing specifically with the liability for agents. And then at G, this decision was referred to by your Lordship's House in Heaton's Transport against TGWU. And again, that was a case where an order had been made against the union by itself, its officers, services, and agents refrained from blacking lorries of particular firms. It was a container dispute. And the union, through its national and local officers, advised the shopstewards to obey the court's order, but nonetheless they went ahead anyway. And findings of contempt were brought, and there was a dispute as to whether or not the union was liable. And the relevant part on page 428 is The unanimous opinions of their lordships was delivered by Lord Wilberforce, referred to the Stancombe decision. It's now necessary to pass to the second stage. After the injunction has been granted, the relevant question now becomes whether breach of the orders were committed for which the respondent union was responsible in law. It's willful disobedience to an injunction which required the respondents to refrain both themselves and by servants, officers, agents from continuing to black the complainant's vehicles. Respondent shop stewards did continue to black the complainant's vehicles. They knew what they were doing. Conscious, intentional, systematic conduct on their part. On the assumption of so doing, acting as agents of the respondents were disobeying the injunction. The question is whether the disobedience was willful in accordance with the established meaning of that word in relation to contempt of court by disobedience to an order of the court. Important to note, there is no question here of contumacious or insulting behaviour or interference with the administration of justice, simply being a disobedience to the court's injunction by the party restrained, and disobedience has been committed by that party through its agents. What is the established meaning of the word willful? And then there's reference to the Industrial Relations Act 1971, and then over the page at B we come back to Trowbridge, Stancombe and Trowbridge, and at D, Mr. Justice Warrington's judgment is cited yet again. And my Lord, at E to G, there is a list of cases which are said to fully accord with what Mr. Justice Warrington has viewed before he pronounced it and afterwards. And at G, it is, Lord Wilberforce continues, it's also the reasonable view because the party in whose favour an order has been made is entitled to have it enforced, and also the effective administration of justice normally requires some penalty for disobedience to an order of a court if the disobedience is more than casual or accidental or unintentional. And then precedents for imposing fines exist. Then if I can ask the court to move on to page 430 at letter E. As is not uncommon, both sides argued that the passages I've just read I held then, but the decision at G, since Heaton's with agents and not with servants, the latter part of the relevant passage from the judgment of Mr. Justice Warrington was not in point, but it would have been inappropriate, and it would have been inappropriate for Lord Wilberforce to refer to it. But if Lord Wilberforce had thought it was erroneous, it was inconceivable that he should have failed to say so. The passage as a whole supported the proposition that disobedience by the servants of a company acting in the course of their employment to an injunction amounted to contempt of court by the employing company, unless the conduct of the employees could be described as merely casual, accidental, and unintentional, and that clearly didn't apply. And then on 431 at C to D, I cannot, however, accept that when formulating the test in these terms, Lord Wilberforce was directing his mind to the case of a servant acting in the course of his employment but in dereliction of his duty. That was not the case before him. It was, however, the case before Mr. Justice Warrington. If Lord Wilberforce had thought Stancombe's case was wrongly decided, he would surely have said so instead of simply approving and applying the passage from Mr. Justice Warrington's judgment, which was relevant to Heaton. There's no inconsistency between that passage and the passage which immediately follows it. Given that liability for contempt does not require any direct intention on the part of an employer to disobey the order, there is nothing to prevent an employing company from being found to have disobeyed an order by its servants as a result of a deliberate act by the servant. In my judgment, the decision in Stancombe's case is good law and should be followed in the present case. The employees have, by their deliberate conduct, made the employers liable, and therefore the finding of contempt was restored, having been set aside by the Court of Appeal. Lord, those cases involve decisions in which there has been the act of a servant or an agent, and the question has not been whether or not the servant or agent knew there was breach of an order. Shop stewards had been told not to do something. The question was whether or not the company, or going back to Stancombe's case, the corporation, was liable for contempt because of the liability of the employee. That will take me only so far against the authorities, however, because if I ask you to look back at 429, the bundle, it's right that just above letter G, when considering authorities subsequent to Stancombe, it is said that it has been upheld in preference to a contrary view expressed in Worthington against Ad Lib Club, in Steiner Products and Steiner Limited, and by Mr. Justice McGaw in the Restrictive Practices Court in Remileage Conference Group, both of which would be first instance decisions and not binding upon this court, and by the Court of Appeal in Knight and Clifton. And it's your lordships and your ladyship need to know that unlike the other cases in this line of authority, Knight and Clifton was a case in which an individual faced a charge of contempt for ploughing up a field over which there was a right of way. And although on the appeal hearing it came in as somewhat of a side with it, I think in relation to cross appeal, the Court of Appeal in that case held that the approach taken by Mr. Justice McGaw in the Mileage Conference Group was correct, and therefore Knight and Clifton is authority for the effect that proof of contention to break the order is not in fact required.
But on one view, what Mr. Justice Warrington was doing was construing Order 42, Rule 31, which is set out on page 427 of our bundle. Any judgment or order against a corporation wilfully disobeyed may be enforced. And that word has now disappeared from the CPR. The provision with which we're concerned is CPR 81.4, which just says if a person required by a judgment to do an act does not do it within the time, or disobeys an order not to do an act, then you can enforce. And the sequestration provision, which is a bit further on in part 81, does exactly the same. It doesn't include that word. So, if anything, one might have thought that the rules have been drafted so as if effectively to follow Justice Warrington.
Well, my Lord, whether or Mr. Justice Warrington.
81.20 is the sequestration. Again, it doesn't include the word willfully, which is what Mr. Justice Warrington was concerned with.
Well, my Lord, your Lordship has the submission that I make on grounds 3 and 4. Can I take, on findings 3 and 4 under ground 3, can I take finding 5?
Just remind me which one that was.
My Lord, yes. It's in relation, finding 5 is core tab 8, pages 56 to 57.
Core bundle.
Core bundle, bill tab 8.
Yeah.
I'm just trying to find my own core bundle in amongst my own little forest of bundles. Yes. Have it?
Failing to sign and return authority letters. Is that one?
Yes, that's the one.
Yeah.
So what page of the core bundle?
56 to 57, lady.
Now,
and
do you accept that so I read the order of the second, was it the second order of Mr. Hochhaus? The solicitors had to give him the authority letters by the 2nd of August. Is it at common ground that they did so?
Well, I'm not entirely sure. I'm happy to accept from Mr. Brown anything he says about that. That's not a point that was taken on the committal. So I'm assuming that the letter was provided either on or very shortly after the 1st of August. And the wording of the order that is said was breached is in paragraph 137 of the judgment. The first respondent shall forthwith sign and return the authority letters provided to him by the applicant solicitors pursuant to their undertakings to the court. And there's no dispute that the authority letter came back on the 15th of August. The question is whether or not that satisfies the definition of forthwith. I'm content to stand with the definition of forthwith relied upon by the respondents, citing in Re Seagull, which is as soon as is reasonably practical. But if one is going to investigate what is reasonably practicable, particularly in the context of a contempt application, it is obviously going to be fact sensitive to a degree. And the nub of this point is it was never raised with the appellant at all.
What do you mean? Before the application for committal, or what?
Well, no, when he was giving his evidence. He was not asked about this at all.
To which the respondents say he'd made the admission and he didn't need to be cross-examined.
Well, he didn't admit that he was in breach. If he had admitted he was in breach, I accept that.
I met with all the conditions of the order except signing the letter.
Yes, well, Lord, that's no more evidence that he admits a breach for the purpose of the committal than him saying, I complied with all the orders. That's his view as to what he did. That's paragraph 80, tab 11, page 280 of the core bundle. And it's dangerous to take those words out of context. If one looks at page 280 of the core bundle at tab 11, paragraph 82, the entire sentence reads, I met with all the conditions of the order except the signing of the letter which was drafted by the jail as I was not living in London at that time. So the idea that the fact that he is not living in London could not possibly be relevant to whether it was practicable for him to return the letter any earlier. It's an obvious issue that should be investigated. The idea that one regards this document drafted by my client when I believe unrepresented.
But wait a minute. He was imposing a condition. He was going to come to the office if he got his passport back. That's what the joint liquidator solicitors refused.
Yes.
And then afterwards he took some advice and delivered the letter to the office.
I understand entirely, I think, the point to which your lordship is driving at, that if he's actually trying to strike a bargain, he can't have provided it as soon as is reasonably practical. Well, that may well be right, but it is a matter that requires there to be some assessment of why he was doing what he was doing and how long he did it, and what advice he took and how long it took him to get that advice and why. It is not an excessive burden to place upon someone seeking to secure finding a committal for them to ask those questions. And as I understand it, the position on the respondent side is we didn't really have enough time to ask questions about all of the matters we wanted to pursue, and therefore we didn't ask any questions about this. One understands the pressure of time in a hearing of this nature, particularly bearing in mind it was dealt with remotely. But I'm afraid what has to bend here is not proper questioning of a party accused of something that exposes him to the risk of imprisonment, but whether or not that matter is pursued.
Yeah. But if we accept what I'm going to call the Stancombe approach, and we take, as my lord has said, that what happened was he just tried to impose a condition that he wouldn't sign unless his passport was handed back to him. On what basis could there be a finding of anything other than contempt?
Well, it depends whether or not that's the only reason for the delay, whether the delay is contributed to by the fact that he's not living in the country. Depends on whether or not it was reasonable for him to take advice on what was happening. How long?
Just explain. He's not living in the country, but he hasn't got a passport. That's what he wants back.
He's not living in London.
Living in London, yes.
No, sorry, my apologies. My apologies. I think I may also have misled the court by saying he was unrepresented at the time, which I took from the style of the document. It may well be that he had solicitors on the record. Yes, I'm being assisted, but I was wrong. I'm grateful.
But your case is broadly that because he says he was not living in London, he should have been questioned to flush out whether that of itself was a good reason why he couldn't.
All it required was, well, why didn't you provide this on the 3rd of August or the 4th or on any date before the 15th, and to see what his response was. And that response would say whether or not it was reasonably practicable for him to have done it earlier. The point that my Lord or Justice Stuart-Smith made is, the answer to that is, there's a time here. So what he had to do had to be done by the time it was reasonably practicable. It's that which can be influenced by where he was and what he was doing and what advice he was taking.
But just looking at the reality of this, when the order is drawn up by the judge, we've all done this. Either there's a sort of toing and froing in front of the judge as to what the dates should be that go in the order, or there's drafts going backwards and forwards between the parties before it's presented to the judge to ensure that the dates that are included are not things that it's going to be difficult or impossible for the the party under the obligation to fulfil. Can't we? There must have been no indication at the hearing or at any time when the order was being drawn up that it was for some reason going to be difficult for Mr. Varma to comply.
Well, look, Milady, I'm not able to assist as to whether or not this was an order which was drawn up in the face of the court, as it were, or whether it was subject of negotiation after the event. I suspect the former, and even if not drawn in the face of the court, I very much doubt that it was subject to negotiation with my client, bearing in mind the history. But that's not the issue. The issue is, even given that the timing was as soon as reasonably practicable, is it appropriate to make a finding of contempt without asking the person who is accused of the contempt, why did you not comply sooner than you actually did? It is a case where he did comply within 2 weeks, and depending on when the letter was actually sent to him and how it was sent, he may not have had the entire 2 weeks. But without asking him, the court can't possibly know. And it's really a variant on the rule of practice and good practice, that if you're actually going to make an accusation against someone, you put it to them and you give them the opportunity to respond. It didn't need long, it just needed that single question. And the submission probably needs nothing more than that. Unless your lordships or your ladyship have any further questions, I think I've probably reached the end of my address.
Thank you very much, Mr. McCoy. Yes, Mr. Brown.
Lady, my lords, may I start by thanking my learned friend for the invitation to be in this row. I'm also following instructions. It's no arrogation on my part that I address you from so close.
It's all to do with COVID, social distancing, how many seats can be occupied, etc., etc.
Exactly so. Can I also apologise that we failed to highlight those passages of the authorities on which we placed reliance, and I hope our attempt to correct that in a one-page note made its way up.
It did, but not in time for me to annotate the authorities, but I half guessed which bits you might be relying on.
Then I apologise again.
Not sure that
Well, my lord is ahead of me again. but I'm sure.
I know.
I'm sure I'll get it
I
at
got
some
a
stage.
note this morning,
Oh,
a two-page note or one-page note, which I'm not sure that it's made its way down to court, but here we are.
I look forward to reading it.
It's not very exciting in and of
It
itself.
actually, I've done you an injustice. It came at 6:30 yesterday. In fact, for a reason which I can't explain, I have 2 copies of it, so I'll give one to my lady.
I've got one here, and I'll be able to survive the rest of the afternoon without. So I'll hand it
Confession
up.
time again. I got it at 6:49. I just haven't spotted it, but I've got it electronically. Thank you.
There's a bit of back covering by Brown and Chipley in that, because of course, if I fail to refer to something, then I hope that I've drawn it to your lordship's attention. But I will try and take your lordships to the passages on which we place particular reliance. Can I just, against the backdrop of us not resisting the application to put in fresh evidence, can I just make some comments on it to clarify the context?
But you don't resist the application.
No. We're in the court's hands as to that application.
Well, I indicated to Mr. McCormick that we would rule on the application in the substantive judgments. But if you're saying you don't oppose it, there's no need for us to do that. We'll just admit it and see where it takes us.
Quite.
All right.
What we've said in our...
I know you said in your supplementary skeleton that it's no use. It doesn't get you anywhere.
Yeah.
But all right.
Can I also just point out that consistently with the dispassionate approach taken by those on this side of the litigation, all of whom are officers of the court, and my lay clients are professional litigants, as the court will no doubt have observed, we haven't on previous occasions opposed late evidence that's been put in by various parties. And this goes to one of the comments that my learned friend made earlier. It was an assumption he made, and it's of course natural that he would make assumptions because he's very fresh in the saddle in these proceedings. He assumed that Mr. Siddhant Varma, that is the son's evidence, was produced right up against a deadline. Well, it wasn't. The deadline for his evidence was the 24th of May 2020. He produced the evidence bit by bit during the trial, and in fact, in respect to some of it, after the closure of his evidential case. So I refer here to the letter purportedly from Nirmala Varma to Mr. Sanjeev Varma. That was produced after I had finished cross-examining him. We didn't oppose the production of the late evidence, but we say lateness, as we have in respect of our skeleton here, goes to weight, which the court can attribute to the evidence.
I think that the greatest emphasis is placed on the evidence that was with your clients before the committal hearing took place.
I think the greatest evidence, my lady, is placed on the evidence that came in on the 10th of June, which was during the committal trial. And that leads me, my lady, to my next point that I'd like to make by way of essential context for the court. The reason that these proceedings happened back to back was because though the committal trial was expedited by Mrs. Justice Fogg, there was an adjournment that was agreed. And then on Mr. Varma's application, the committal hearing was adjourned again. That application was moved on the basis that he said he thought he had contracted COVID-19. And part of the order made by Mr. Justice Fancourt on that occasion was that he should make every attempt to get a test. He didn't have COVID-19. Part of the picture at that point was that he'd also just recently changed legal representatives. So Jane's solicitors came on board and Mr. James Leonard. They knew, because there was some jostling about diaries and when the matter ought to be listed, that the trial before Judge Prentice was going to take place immediately after, in the week immediately after the committal hearing. So the assumption is wrong that Mr. Siddhant Varma's evidence, which included the evidence of Taru Dumra and Manju Dumra, that is respectively the ex-wife and the grandmother on the other side of the family, was up against the deadline. It was way after the evidential deadline and during the committal hearing. Maloney Friend fairly referred to healthy scepticism on our part about whether or not there's communication between Mr. Varma on the one hand and the rest of his family on the other in relation to these proceedings. He took the court quite properly to that part of the cross-examination where I was asking about a document which had been produced late, which was the MBG accounts document, which was produced in purport to support the story about the diamonds and jewellery. Again, it's a Mr. Varma document, so it's not one which we say we would have any duty of disclosure in respect of. But in relation to that, when pressed, he admitted that his father had given it to him, which Maloney Friend correctly, very properly, took the court to. Can I take the court now in the application bundle to page 103? The start of each document, which is a letter from James solicitors, is on page 102.
Janes were acting for Mr. Varma when?
James took over shortly before the hearing before Mr. Justice Fancourt. Mr. Varma was represented at the original directions hearing and at the directions hearing before Mr. Justice Fancourt, albeit by different solicitors. The original directions hearing was before Mrs. Justice Falk. So James came on board between those two hearings. I think it was the 12th of May that we actually got the change of representation. The 11th of May, I'm corrected.
Right.
So the relevant bit of this letter that I'd just like to take the court to is at paragraph 2. It says this. We're trying to understand in this correspondence, my lady, my lords, what they thought we had, which they didn't have, which they thought had any materiality to whether or not the company received diamonds and jewellery in exchange for the 3.1 million. And they say this is James, Mr. Varma's solicitors. Neither our client nor we are in possession of the trial bundle relating to the proceedings against Mr. Siddhant Varma. We've been provided with an index by Mr. Siddhant Varma's solicitors. Pausing there, that shows communication between the legal teams, whether or not the family rift prevented communication between the individual members of the family. But this was only received after we had considered the judgment in Mr. Siddhant Varma's trial. Our instructions are that our client and Mr. Siddhant Varma are not on good terms, and they were not in communication during either trial. I pause there to comment that that's demonstrably untrue by reference to the part of the cross-examination that my own friend has already taken you to, because Siddhant Varma accepted when asked that he had received that document from Sanjeev Varma. He might not have responded by saying, "Thanks, love you, Dad," but he was in receipt of documents that he put before the court in the trial. The next point I want to deal with, and I want to try and do this without drifting into submissions on the ground, which I'm going to try and address methodically one by one. Next point I want to make is this. I'm not sure I understand the counterfactual that's being proposed by my learned friend. It's his case, and I understand it's that part of his case on which he says he's on the strongest footing. That had the court had the evidence from Mum and from Grandma on the other side about the single piece of jewellery, and had it had the evidence from Siddhant Varma, that there might have been a different result in respect of the question as to the existence of the diamonds. And what I don't understand about this is it being proposed that that evidence ought to have been before the court and therefore the whole result is unsafe? Or is it being said that at the rehearing that's being proposed, if you overturn the judgment of HHJ Johns QC, that they will now attend and give evidence? Because one of the things my learned friend said that I have real difficulty with is that it was on Mr. Varma's evidence alone that he was found to be in these various contempts. It's demonstrably not the case. There's a sea of evidence before the court, bank statements, company documents. That is how, for example, Judge Johns comes to the conclusion that there was a commercial improbability to the transaction, and my Lord Justice Lewison has been picking up on some of those points today by contrasting the timing of all the payments, which was between June and November 2017, and the settlement agreement, which Judge Agnello found to be a fabrication, decision that was echoed in the judgment of Judge Johns, and what was supposed to be going on with the hotel development. So there was this commercial improbability to it. As I say, there was a sea of evidence. There was also, pertinently, for the application that's being moved by my learned friend, evidence from other people who didn't attend, including members of Mr. Varma's family. Varma purported to corroborate Mr. Varma's account of what happened in Mumbai in June 2018, when Judge Johns found that Mr. Varma was in London. But he didn't attend to give evidence. So the weight that was attributed to that was the appropriate weight, which was not very much. There was also evidence from a lady called Nianta Bois, who didn't attend so that she could be cross-examined. Neither of them gave particularly good reasons, by the way, why they weren't there. And that was evidence designed to explain how Mr. Varma was spending money in London on his bank card when he said he was in Mumbai doing a diamonds deal for the company. And that was evidence that also was disbelieved, having heard Mr. Varma over 3 days. So I reject the assertion, if it's being made, that Mr. Varma was convicted on the strength of the evidence that he gave to the court alone. That simply wasn't the case. The difficulty that this appellate court finds itself in, which is one that appellate courts always have, and which my Lord Justice Lewison has commented upon in Fage and Shabani, is that we're island hopping here. We're in a slightly more extreme situation here. We're looking at the stars, according to Mr. Varma, in a huge constellation, where the rest of the constellation isn't before the court. It's a huge problem. The other problem at the root of this, and this is something I fundamentally do not understand about my learned friend's case, I understand that the rift in the family is supposed to have been caused by the fact that poor Siddhant Varma has been dragged into these proceedings because of his father's conduct. His father's conduct is the misappropriation of company funds, which forms the basis of Contempt 1, which is that he lied when he said that the company received good consideration for the money it paid over, namely the diamonds and jewellery. There wouldn't be any dispute between, or any rift between the members of the Varma family if, indeed, the company had received good consideration for the money it paid over. In fact,
I don't think Mr. McCormick was saying that Mr. Varma Senior is blameless in the creation of this rift, just that there is a rift, and that was why he didn't have access to the same evidence as was provided to the liquidators during the course of the committal.
Perhaps I haven't made my point clearly, my lady. The point, as I understand it, is that in order to invite the court to draw the inference that help wasn't available from members of Mr. Varma's family, he said, by the way, he was on good terms with his wife. In order to draw the inference, we are asked to accept that Siddhant Varma is angry at his father because Siddhant Varma has been dragged into these proceedings because of his father's conduct. Well, his father's conduct is the misappropriation of money from the company. Had the company received diamonds and jewellery, there would have been no misappropriation. He wouldn't be facing these claims. So I don't understand what it is about Mr. Varma's conduct that is said to be, if it is true that the company received diamonds and jewellery, potentially causative of any rift.
Put it slightly another way, that father and son ought to be making common cause on that question.
Right.
The son's case, as it turned out, as I understand it, is, well, I didn't really know where this money was coming from. I assumed it was all from my father and above board, because he's a generous man and I'm used to lots of money.
Yes. And could I pick on, my lord, on something your lordship said earlier about what Siddhant Varma's case actually was? I'll come to this in due course and take the court to the passages of the cross-examination on which I rely. he said in his evidence, he made the positive assertion that the £2 million he received came from diamonds and jewellery that came from his grandmother. And we had bank statements that demonstrated that that wasn't the case. So I asked him, out of fairness to him, do you make that positive assertion? I'm paraphrasing the cross-examination. And he said, no, I'm not in a position to do so. I don't know. Later in the cross-examination, he said that he'd been the victim of a lie told by his father to him in 2017. Okay, so in the course of the cross-examination, his evidence shifted from saying, I don't know, I'm an innocent bystander, as my Lord Justice Lewison has identified, to saying, no, I'm the victim of a lie. And you can only be the victim of a lie if the diamonds and jewellery weren't given as consideration for the money that was taken from the company.
How's that evidence against the father?
Sorry?
How is that evidence against the father?
Well, it's not evidence that helps him. What my learned friend is saying is if Sidant Varma's evidence had been before His Honour Judge Johns,
Yes,
that might have influenced the conclusion. Well, point one, without cross-examination, I suggest it wouldn't have influenced it much. And we know what happens with cross-examination, which is he says, I don't know about the origin of these monies. And he goes on to say, in the protestation of his innocence, if I'd have known they were company monies, I wouldn't have touched them with a barge pole. Not the expression he uses, but that's the thrust of his evidence.
Yeah.
So my point is that if Sidant Varma had attended, then he would have said the same as he said to me in cross-examination, which was that he's a victim of a lie told by his father, or that he didn't know the origin, which advances matters not one bit.
Sorry, you're saying if he had attended the committal proceedings, his evidence would have been the same as it was at the...
Before Judge Prentice.
Before Judge Prentice.
Yeah.
But by the time of Judge Prentice, there was all... Was the result of the committal proceedings known?
No. No, that came after the trial, my lady. And if he didn't attend, because of the rift that we're supposed to assume is in place in the Varma family, then I would have said, well, you can't attribute much weight to this, and in any event, he doesn't know anything about it, and look at the bank statement, which demonstrate that the money came from the company, was looped through accounts in the UAE, and then came to Sidant Varma's account. Some of it came back to Mr. Varma.
But the thrust of what he was saying, I mean, I should imagine it's not unusual that money from his father doesn't actually come directly from a bank account in his father's name. It's moved through various trusts and companies. We're familiar with how these things work. But the thrust of his defence was, I had been told that my grandmother was making an inter-virus gift to me as part of my inheritance. It was going to be through jewels.
Yes.
Then this £2 million arrives from one of my father's companies, and I assumed that the two things were linked, and that was what I was getting. I mean, that was a base. And,
yes.
and he says that's why he didn't know that it was misappropriated money.
Exactly.
But the relevance of that evidence for the finding one in the committal is that it supports, Mr. McCormick says, this background situation of the grandmother having a lot of diamonds and rubies and gold, deciding that she's going to dispose of it before her death and share it out, actually then doing something about it, so that the jewels do exist. Now, of course, it may still well be a breach of duty in all sorts of ways for Mr. Varma to cause his company to buy the jewels, because it's not what the company's for. But that's not what we're dealing with. What we're dealing with is a finding, for which he may be sent to prison, that the jewels didn't exist and that he lied in his affidavit in saying that they did, and that there'd been this, you may say it's kind of all very dubious. Yes, it's a very dubious transaction, but the question is not whether it was dubious, but whether it happened.
M'lady, precisely.
Yeah.
And your ladyship has it exactly right, because what my learned friend has, if he doesn't mind me pulling his leg, ambitiously called, quote, the jewellery issue, unquote, isn't a jewellery issue at all. The question for the court, the question for His Honour Judge Johns, which he answered, giving 8 reasons, one of which related to the non-existence of the diamonds, was whether or not Mr. Varma had lied when he said the 3.1 million was paid against diamonds and jewellery. And what Mr. Varma said is that near Varma, and the court can decide for itself whether this story has, as I say, inherently fabulous quality. The jewellery came from near Marlow Varma to Mr. Varma, who then liquidated it, he says. And then he says he invested it as a capital contribution in GCFZE. And then he says GCFZE, in a transaction on which he was on both sides, in Mumbai, gave the jewellery and diamonds over to the company in exchange for the company money that had been transferred almost a year earlier. So what I say simply, and I'll come on to, I hope, make good this submission, is a bit like with Manit Singh. The existence of Manit Singh has no relevance whatsoever to whether or not he was involved in the company. That is demonstrated by looking at whether or not he was involved in the company. The existence of an intention to make a bequest or a lifetime gift, Mr. Varma was inconsistent on that, has nothing whatsoever to do with the question to which His Honour Judge Johns was directing his mind, which is, did the company in this transaction receive consideration, namely the diamonds and jewellery, against the money? Nothing to do with that. Similarly, my lady, I want to drag the court back if it's being lured by the simplicity of the approach that's being suggested to the issue by my learned friend, to lure the court back from that danger. Careful consideration, which has been productive of cogent reasons in the judgment, was given to whether or not, when GCFZE, on Mr. Varma's narrative, had the diamonds and jewellery, it gave them over to the company. And that is the critical question. Whether or not the diamonds and jewellery exist in the world is neither here nor there to that question. The question is whether or not they were given over. That was what His Honour Judge Johns was addressing his mind to. And I do say there is, at various times in this case, one has a sense of surreality. And my learned friend, I thought, was going to talk about me having a case.
So you say the question is whether the jewellery was given over to the company in exchange for the 3.1 million.
Precisely. And, my lady, that's probably an appropriate point for me to assist to the extent I can with page references.
Well, why didn't you do that at 2 o'clock?
It's a better point
Yeah,
than shut
because
up.
I think it's becoming important to have a much clearer idea than I currently have at the moment about what is the allegation of
Yes.
contempt,
May I just do
what
that?
was said. Well, no, I'd rather have it after.
I think we'll do that at 2 o'clock.
Okay. Great.
2 o'clock. You can go get, I'm not going to get you to
Just if you could come out, because we're not really social distancing here. And my name is... Thank you. Okay, I'll lock the door for the lunchtime. So if you want to move anything, you can.
Okay, thanks.
false statement is in one of the question and answer ones, so it's actually just straight off answer the question. I don't think it needs more context than is in the bundle.
That's good.
Yeah. So,
Thank you.
So, do we have everything good?
I don't think we have the original affidavit, but we have that quote. Right.
So we don't need to get, I don't need to get his original, is his statement in there as well?
Yeah. Sorry.
Thank you very much.
Okay, thank you.
Just going to grab my white book. I'm so sorry.
Open up about 10 to 2.